Okay. Thank you, Prof. I think we're going to start. Welcome back, student, to the second session for our discussion. As I've already alluded, and Prof as well, that the second session will be focused on the feedback for assignment 2. Prof will go through with you on how we had expected you to respond to this question. Without wasting time, Prof, the podium is yours.
Thank you. Can everybody hear me clearly? Can you give me feedback on that, please, Professor Mokotong?
Yes, everybody can hear you. The students are also reacting with their hands. Everything is clear. It's audible on their side. Prof
Right.
can continue.
Thank
you, student.
Then I'm just going to see whether I can make the typeface a little bit bigger, perhaps.
Yes.
To improve the legibility.
Definitely.
Is that better?
Yeah, much better, Prof.
Okay. Okay.
And student, if you can't see it, you already have the questions on your side. You are more than welcome to refer to it. It has not changed. It's still the same as it appeared on your or on the portal.
All right. So can you see my question exam, the assignment question clearly there now?
Yeah, we can see it. Even the students are confirming.
Great. Thank you. Welcome back, students. I hope you grabbed a cup of coffee. I certainly have. Let's continue. So assignment 02 does not contribute to your year mark, but it is nevertheless a very important exercise for you because this is the kind of question that you are going to get in the exam. So this feedback is very important because it will enable you to give yourself marks on how well you did when you attempted this question. So in other words, please evaluate your own performance and not only what you have written, but how you approached everything, your thought processes, how you did your research, how you analyzed the question, all of that. I'm going to give you some pointers on that. So please listen carefully, decide how you did, and crucially, decide how you can improve so that when you sit in the exam and you are a bit nervous and time is limited, that you perform optimally and that you give us the best possible result, because we want all of you to pass this module and to have good memories of it as far as possible. All right, so let's quickly read through the question. At the Shop Till You Drop shopping mall, hand sanitizer dispensers have been installed at all the pedestrian entrances. Notices have been placed near the dispensers in which customers are urged to sanitize their hands at the dispensers before entering the mall. At entrance B, the dispenser has been malfunctioning for half a week. It spills sanitizing liquid onto the floor in such large quantities that the liquid does not evaporate immediately, but forms a small puddle around the base of the dispenser. Because the lighting at entrance B is rather on the dim side, the puddle is not readily visible unless one specifically looks out for it. The management of the mall is aware of this situation, but does not do anything about it. Miss C is an elderly lady whose eyesight is not very good, and she is not particularly steady on her legs, but she loves shopping. She arrives at entrance B, reads the notice, and proceeds to sanitize her hands. This requires her to put her one foot on a pedal and push down on it to activate the dispenser. As she attempts to do this, she slips in the puddle and falls. She sustains serious injuries and is hospitalized. After a long and costly bout in hospital, she is discharged. Miss C wishes to institute an action for damages against the management of the Shop Till You Drop shopping mall and approaches you for legal advice. Write an opinion properly substantiated with reference to case law only on the wrongfulness of the conduct of the management of the shop till you drop shopping mall. Okay, for 30 marks. Now, obviously, if this question counts 30 marks, you are going to write a lot. This means this is really a long question. It's really an essay, and how does one approach it? So the first thing is stay calm. In the exam, you're going to get several questions like this, and when you are bombarded by such a lot of words, it's easy to panic and to get nervous, but don't do that. Stay calm. If you have prepared yourselves well, you will be able to answer all the questions. So the first thing is, remember now, to have a delict, you need to have 5 elements. That's very important. But because the exam is divided into different questions, you can assume that a given question will not deal with all 5 elements. A given question will usually deal with only one specific element. Not necessarily, sometimes it can combine aspects of more than one element, but the important thing is you must first decide what part of the work are you being able, or are you asked now to give account of. That's the first important thing. Now, usually you find this first indication in the last sentence of the question. Not always, but usually. And usually there's something that you can look at to get a clue about this. So let's see what the last sentence is. Write an opinion properly substantiated with reference to case law. That's obviously completely superfluous. If there's case law on any question that you're getting, you're going to cite that case law. All right, so that's really not necessary for us to say that, but we do so anyway. But okay, you know you must do that. Now, only on the wrongfulness of the conduct of the management of the shop till you drop shopping mall. So, your defendant is the shopping mall, okay? And you must write only on the wrongfulness of the conduct. So what is this question about? It is about wrongfulness. It's not about fault. It's not about causation. It's not about damage. It's not about conduct. It's about the wrongfulness of the conduct. Okay, so you know you're going to write on wrongfulness. Okay, so now your brain must activate everything that you know about wrongfulness. So the first thing that you will remember is there is basically one criterion for wrongfulness, a big overarching criterion, and that is the boni mores. But the other thing that you will remember is that there are 2 other approaches which we normally use. One is infringement of a subjective right. The other one is breach of a legal duty. Now, which one is going to be the correct one in this instance? So to do that, we need to know what kind of conduct we are speaking about. Because if it's a commission, then we will use infringement of a subjective right. If it's an omission, we will use breach of a legal duty. Okay, so these are the thought processes that must go through your brain before you start answering. So now we must go back to the question and analyze it. So what we want to find out is, have we got an omission here or a commission? Because that will determine what we are going to write about the wrongfulness. Okay, so what happens there? Okay, there's a dispenser, it's leaking, there's a dangerous situation developing there, and what happens? The management of the mall is aware of the situation, but does not do anything about it. That sounds like an omission. All right. So now you know what to do. You've got the conduct, the form of conduct is an omission. The question deals with wrongfulness of a given kind of conduct. The conduct is omission. It's not identified for you. You must do it yourself. So you must tell us this is an omission. Okay. And then you must proceed to tell us how do you determine the wrongfulness. And you are going to have to cite case law. So let's see what a model answer could look like. All right. So first, we start with the general, and then we go to the specific. So because this question is on wrongfulness, you can first give us information on what wrongfulness is and what the test for wrongfulness is. Remember that every time you must look at the criteria, at definitions, at requirements, and you must always look at this thing from the side of the plaintiff and the side of the defendant. Okay, so let's start with generalities. You will see there, wrongfulness is infringement of a legally protected interest in a legally reprehensible way or in violation of a legal norm. And they're the main test. The main norm or criterion is the bonum mores or the legal convictions of the community. Doesn't matter which one of those two you mention, it's the same thing, so you will get your 1 mark there. The test is objective, it's based on reasonableness, it must reflect the values of the Constitution. The Carmichael case is the important authority there. Must be seen, the legal convictions of the community must be seen as the legal convictions of the legal policy makers of the community, such as the legislature or the judges, and Schultz versus Butt is the authority for that. You see those 1 marks are highlighted in blue there, not in yellow as the others. That's my indication to the markers that those 2 questions are more like bonus marks. So in other words, I don't see them as so crucial as some of the others, but if you think of that and you write that, then you're definitely going to get marks for that. 2 practical applications of the bonum mores, and that's what we've been reasoning about, is the infringement of a subjective right and the breach of a legal duty. Okay, and now wrongfulness of omissions, because you have now already seen that the kind of conduct in our given scenario is an omission. So now you're going to write about omissions and the wrongfulness of omissions. So you say wrongfulness of omissions is determined by asking whether there was a legal duty on the defendant, and that's going to get you 1 mark. And there are cases that you can cite. The Van Eden case is a nice one. The Ewels case is a good one. All right, Ewels case is the crucial, it's the locus classicus on that. Okay. Causing of harm by omission is not prima facie wrongful, or it's prima facie lawful. There's no general duty to prevent loss by positive conduct. And now we get to the important stuff again. Whether a legal duty rested on a defendant must be determined with reference to the bonum mores. So that's the link between the bonum mores, which is the upper criterion, and the criterion of the legal duty. And then all the factors that indicate that the legal duty was present must be considered. And there is not a closed number of such factors. And then what are these factors? Like I say, there's a lot to study. So here you can name some of those factors. One of them is prior conduct, or the omissio per commissionem rule. One of them is control over a dangerous object, and all those others. So you see there at the end of them, I give a direction to the markers there. You can give 1 mark for each of these factors up to a maximum of 4. So the other thing that you are now getting an insight in is that this question is counting 30 marks. But if you add up all these 1 marks in this memorandum, you will see that they add up to quite a lot more than 30. So it is possible to get full marks for this question if you know your work well, because the memorandum is drawn in such a way that there are lots of extra marks that you can be awarded. Obviously, you can't get a mark of higher than 30, but it is entirely possible. It is definitely possible, if you know your work, to reach that 30 marks. Okay, so where are we now? Okay, now let's go back quickly. So what have you done up till now? You have given us some basic information on wrongfulness, how it is established. You started with a general, with a boni mores, and with telling us how wrongfulness operates, that it is objective, that it's about reasonableness, that it is about the infringement of interests, all of those things, that it is about what is legally reprehensible, etc. You have given us some case law. Then you move to the specific, and you said, okay, we have two ways. One is the infringement of a right, the other one is the legal duty. And then you said, but now, when we are dealing with omissions, this is how it works. And then you gave us specific information on that. Okay. Now, let's go back to the question quickly. Okay, so the first thing that we see there is there are hand sanitizers at the entrances. They have been installed there. They've been installed, obviously, by the management of the mall. So what is that? Is that an omission? No, that is positive conduct. Okay. Then after that, we had an omission in the sense that a dangerous situation developed, and then the mall did nothing about that. Now, if you know your work well, that should immediately ring a bell, loud and clear. And that is that we are dealing with one of those very important factors that indicate the presence of a legal duty. And it is called prior conduct, and it refers to the so-called omissio per commissionem rule. So what that rule says is that if the defendant has, by positive conduct, by a commissio, created a new source of danger, and then he omits to guard against others being harmed by that scenario, then his omission can be wrongful, because then there will be a legal duty on him from the side of the boni mores to prevent others from being harmed by that dangerous situation that he created. All right. And there you also see that the management of the mall is aware of this situation, but does not do anything about it. That's also quite important information. Okay, so let's go back to our factors that we have already listed there. We have there where my cursor is, there's no closed number of such factors. They include prior conduct, omissio per commissionem. This is present in our set of facts. Control over a dangerous object. This is also present in our set of facts. Because in a sense, because that dispenser is leaking, because there is a puddle of moisture there, and because the lighting there is not very good, that is a dangerous object. And the management of the mall is in control of that. So there's another factor. Knowledge, foresight of possible harm. We have read that the management is aware of the scenario, but they do nothing about it. So there's another factor that is also available in this instance. Then there are rules of law, special relationship, particular office, contractual undertaking for safety, creation of an impression, danger of limitless liability, vulnerability to risk, interplay of factors. Okay, most of those others don't seem to be specifically present in our set of facts, but at least three of those factors are present. So we are slowly being nudged into the direction that there is going to be a legal duty on the management of the mall, and probably their omission is going to be wrongful. All right, so the first thing is, you will know that in the textbook, there is a long history about the development of the law around the whole aspect of prior conduct, or the omissio per commissionem rule. And you will know that there's a lot of cases mentioned in the text. And where you see something like that, you know that we will probably want to know that you know about those cases. So if there's a bit of history like that, and your question counts 30 marks, then it is always a safe bet to tell us some of that history. So let's see what the model answer looks like. Okay, so the last time we were there when we said, 1 mark each up to a maximum of 4. That was for mentioning those factors. Okay, now we go over to an in-depth discussion of one of those factors, the most important one, prior conduct or omissio per commissionem, because as I say, you know, there's a lot of that in the textbook. There are a lot of cases, so that's probably very safe to give that back to your lecturer, to the markers. Okay, so prior conduct, omissio per commissionem, is present where the defendant creates a new source of danger by positive conduct or commission and then causes harm by omission. Originally, this was regarded as an indispensable requirement for liability for omission for 1 mark, and then you cite the Halliwell case for a mark, and you mention the municipality cases, because those municipality cases were really the cases in which this whole thing developed. This view was, and you can use one of those words, eroded, adapted, progressively rejected, whatever, in Silva's Fishing Corporation, the Regal case, and the Quathlamba case. All of those cases were stepping stones towards the important one, the Ewels case. And then we get, and you can get a mark for mentioning any of those cases. Finally rejected in Ewels, and obviously you get a mark for that, and confirmed in Bakkerud. That was a municipality case which specifically confirmed that Ewels was now the correct position. Okay, so now we know the following. Okay. Okay, there's actually a part missing in this answer that I see now, which I'm going to add. By the way, we will post this this model answer. We will send it to you. We will put it as an attachment to one of the announcements, so you will be able to look at it at your leisure. But I see there's an important part that actually was omitted here, and that is that in the Ewels case, it was decided the things that stand higher up there. Let's just go back to that. There we go. Ewels case. There's no whether a legal duty rested must be determined with reference to the boni mores, and all the factors must be present. So what we must say is because prior conduct was present, that's a strong indication that there was a legal duty on the management and therefore that the conduct was wrongfulness. Okay, so let's see what the application is going to be. So there you see I've said application, and now let's see. The management of the mall created a new source of danger, that is prior conduct, or it was in control of a dangerous object, and that gets you another mark, and it had knowledge, foresight of possible harm. So there you demonstrate to us that you were able to identify the presence of all these factors in the set of facts above, and you give that to us. And then you say, accordingly, there was a legal duty on the management. You could have said, these were factors that strongly indicated that there was a legal duty on the management. Okay, and therefore, the conduct was wrongful, for another mark. You could also have elaborated much more. You could have said, again, that the ultimate question remains whether there is a legal duty, and the ultimate criterion for the legal duty remains the boni mores, but these factors are extremely strong indications that the legal duty exists. Okay, then wrongfulness may also be seen as the reasonableness of holding a defendant liable. You will remember that the infringement of a subjective right and the breach of a legal duty are the two original forms or the two original criteria for determining wrongfulness of conduct, and they both emanate from the boni mores. But a new approach developed in more recent case law, and this is this one of holding the reasonableness of holding the defendant liable. So you can cite some case law where this was was done. The telematrix case is one, the Crown Chickens case is another one, and Leroux versus Day. You can get a mark for mentioning any one of those. And then, of course, you know that your textbook writers are extremely critical of this new approach. You can get a mark for mentioning that. But then you also know that I told you that the new approach can actually be reconciled with the traditional or other approaches, and there were important cases in which this reconciliatory approach was followed. The South African Hang and Paragliding Association case, the Fetal Assessment Center case, Mass Stores case, and the important one, the one that I really like a lot, the Loureiro case. And some of those cases, like the Loureiro case specifically, are constitutional law cases, or constitutional court cases. So our highest courts have actually endorsed this approach, reconciling the original two approaches, the traditional approaches, and this new approach of the reasonableness of holding the defendant liable. Okay, so now we must apply the new approach. We must also apply this one to our set of facts. And then we can say there that applying this approach to the given facts, there is no reason not to hold the mall management liable. So the conclusion remains that their conduct was wrongful. Because if you look at those cases and you look at this whole approach, you will see that the basic point of departure of the courts is to look at the scenario. They determine whether fault and all the other elements are present, and then when they get to wrongfulness, they say, but is it now on policy grounds reasonable to hold the defendant liable? And then they find some reason why it is not reasonable, and then they will say wrongfulness is not present. But in our given case, there is no, if we go and look at the facts, there is no reason why it is unreasonable to hold them all liable. In fact, there are definite factors indicating that it is reasonable to hold them liable, and those are the same factors that pointed towards the existence of a legal duty. So even if we apply the new approach, then the conclusion remains the same, and the conduct of the mall is wrongful. All right, so that is a model answer. There are other things that you can write because the topic of wrongfulness is vast. The approach when we prepare ourselves to mark this kind of question is to have all our markers study the whole part of wrongfulness in the study guide and in the textbook in detail, so that if they come up, if you as the students come up with things that are not in the memo, but they are correct, that they are equipped to give the correct answer. And what we do in the process of monitoring this is we have frequent feedback sessions, and then the markers would tell us, okay, the students are now coming up with this, that, and the other. Can we give marks for that? And then we say yes. And then we let everybody know so that that the marks are given for that and allocated for that. All right, so that is your basic way of approaching a question like that. And if you are ready to do this kind of thing, then you are ready for the exam. So think back on what you wrote. Go and have a look again at what you wrote in the assignment. Once you get this memorandum, which I'm going to amplify a little bit because I saw a few things that I can elaborate a bit on even more, please go and compare that. You have listened to us and you have been given some ideas on how to approach the question, how to read it, and how to then first give us the general, then the specific, to start logically with basic tests or definitions, then proceed to requirements, then proceed to application. And if you do that with every question, you are well away. All right. So Perhaps a couple of quick pointers on the upcoming exam. Think of our basic approach to the law of delict. We have 5 elements, and then we have a couple of other, how shall I call it, other aspects of delict that are also being treated later on in your textbook. What I can tell you is that your first 4 elements, conduct, wrongfulness, fault, and causation, are by far, in terms of volume of your study matter, the most important for the exam. So you will get your most difficult questions and your longest questions out of those 4 elements: conduct, wrongfulness, fault, and causation. And I think if you think back on the matter that you have already studied, you will realize that wrongfulness and fault are actually the biggest topics of those 4. So that will definitely give you an idea of where most of the questions and the questions that count most of the marks come from. Then we have given you some pointers in the other 2 discussion classes, especially the previous one that was earlier today, on how to approach the other things. And we have pointed out where you don't need to study that specific topic in such a lot of depth. And we have pointed out to you that you must let yourself be guided by the study guide in that respect. And we have given you some tips on certain things that we like to ask. The other thing is, like I say, it's important to identify in each question what that question is about. Now, note that in this question, that was your assignment. Say you get this question in the exam. This question deals with wrongfulness. There's nothing about fault in this question. There's actually also very, very little about conduct. Yes, you need to identify the kind of conduct. You need to know that it is omission, that it is a form of omission that is present in the set of facts, because otherwise you won't answer the wrongfulness question correctly. But you are not giving us much information on conduct in this question. And there is also nothing of causation here. I mean, we're not asking you, is there factual causation? Is there legal causation? We're not asking you about damage. This question is only on wrongfulness. So if I could give you another tip, when you get your exam paper, quickly survey the whole paper and make a note for yourself on what the various questions are about, so that you can say, okay, question 1 is about conduct. Question 2 is about wrongfulness. Question 3 is about wrongfulness. Question 4, this is about fault. Question 5, okay, this is also about fault. Question 6, this is about causation. Is it about factual or legal? Oh, it looks as if it's about both. Okay. Question 7, this is about a specific form of injuria. This next one. So have a quick look and identify quickly what the various questions are about. And as I said, the important thing is you can usually see that from the last sentence in your set of facts, because that's where you usually get your final instruction. Discuss the wrongfulness, or tell us whether there is factual or legal causation or whatever. So that last sentence will usually give you the clue as to that. And then you can assume that we don't want you to repeat yourselves. So if you find yourself writing a lot on the bony mores in one question, and then in a second question you want to write a lot about the bony mores again, then there must be a red light going off, because that's not going to be an economic way of using your time and your marks. So probably you are doing something wrong if that happens. So if you find that you want to discuss the reasonable person in every single question, then that must be a red light as well. And then you must go and have a look again. Which question specifically deals with negligence? That's the one where I must discuss the reasonable person, not in all these others. You know, it sounds reasonable to discuss the reasonable person everywhere, but that's not what we want. So determine which question deals with negligence. That's the one where you are going to discuss the reasonable person. Okay, so in other words, be systematic in your approach to the exam and be calm and be analytical. And then if you have done what we have told you to do, in other words, you have studied and memorized those definitions, those tests, those requirements, and you know how to apply them, and you know also the defenses, because you're also approaching each element from both sides, both that of the plaintiff and that of the defendant, then you should be well away. And of course, you can always cite case law where applicable. Then there's no need to panic, and then you will obviously get good marks. Next thing is, we may combine different aspects in a given question. So for instance, we can have a question in which we combine, say, negligence and contributory fault. Okay, so we can have a question that deals with more than one part, and we can, for instance, combine negligence with vicarious liability, or perhaps we can combine conduct with aspects of causation. But then it must always be clearly spelled out, and usually in that last sentence or those last few sentences. So if you find yourself combining different elements without getting a specific instruction in the question that you must do so, then you must be a little bit doubtful about your approach. But obviously, if the question specifies instructions in such a manner that you realize, oh, okay, I must not only discuss negligence here, I must also discuss vicarious liability, then of course you must do that. All right, the important thing is to always start from the general, then the specific, then the application, and substantiate throughout. I think with that, I have said most of the original things that I wanted to say. I think I'm going to unshare my screen. And Professor Mokotong, I think I'm going to hand back to you for direction of what we do next, please.
Okay, Prof, we've got two questions from Lituma and Refilwe.
Okay.
Lituma says that, does the legal duty only arise if there is prior conduct, and in the case of employment, such as police, medical doctors? That is Lituma. That's the question for Lituma. Maybe Prof can respond to that, and then after that, I'll read to you Refilwe's question.
Okay, so the legal duty it's not limited to given scenarios. Like we have said, the legal duty is mainly dependent on the boni mores, which is very wide and very flexible and fairly vague. There are certain factors which have crystallized in case law, which indicate very strongly that there will be a legal duty, and prior conduct is one of them, control over a dangerous object is the other, but it's not limited to those instances. So no, there are many different scenarios in which a legal duty can arise, but it will always help if you can find in your set of facts one of those or more than one of those factors which you know point towards the existence of a legal duty, because what you can do then is you can rely on previous case law, and you can say, okay, well, in Kwatlamba we had a scenario where there was a control over a dangerous object, or in say Bakkerud we had a situation where there was prior conduct or whatever. So then you can cite previous case law. That makes it easier, but it's not limited to those instances. The other thing is liability for omission does not only occur in an employer-employee situation. No, not necessarily. It can be a private individual acting in his own capacity as well.
Thank you, Prof. Prof, I'm not sure, Refilo Ramahaha is not that clear, but let me read to you what she wrote, what she posted on the chat. Refilo says that, so we don't need to apply all the factors to the fact that we mentioned, the legal duty to act factors, or boni more. It appears that Prof only applied prior conduct to the facts, or did I miss something?
Okay, yes. To our specific facts, I pointed out that there were 3 of those factors present. One of them was prior conduct. The other one was control over a dangerous object, and the other one was the knowledge or the foresight of the potential of harm. So we mentioned all of those, um, and all of them were applied in the sense that in the answer we would say all of these indicate the presence of a legal duty. But what is true is that we wrote much more on prior conduct than on the other 2. The other 2 we basically just mentioned. And the reason for this is because if you study the law of delict, you find that those cases dealing with prior conduct, with the omissio per commissionem rule, those cases provide the important history of development that took place in that part of the case. So if you read your textbook, you will see that this is where all the important development took place, and there are many cases mentioned there. So that's the reason why we wrote more about that. On the other hand, if you as a student made an extremely deep study of, say, control over a dangerous object, and you wanted to give us more information on that, that would have earned you marks as well.
Thank you, Prof. Prof, we've got Tepo Mabisela. Apparently, he might have missed something. He's requesting Prof to kindly repeat what you said about answering in terms of general and specific.
Okay, that's just how shall I put it? It's a little recipe for answering your questions methodically. So to make as an example again wrongfulness, the widest or the most general criterion for wrongfulness is the boni mores. So mention that first. Then you go to what is more specific. So then you go to, okay, we get infringement of a right, we get breach of a legal duty, we also get the reasonableness of holding the defendant liable. And then from the more specific, you decide which one is the most applicable in your set of facts, and then you discuss that in far greater depth. And that is when you come to the specific requirements and to all the case law, etc., etc. And I must mention here that it could be that the question is asked in such a way that more than one of those possibilities can apply. Then you discuss all of those possibilities in detail. But if it's clear that only one or only 2 or 3 of them apply more directly to your set of facts, then you go into more detail there. So let's apply the same thing to, say, causation. Okay. You get a question on causation, and say it's a 30-mark question or a 20-mark question, and the question doesn't tell you whether you are going to establish factual or legal causation. How will we apply the same method to such a question? So again, you start with what is general. You tell us basically what causation is, and you tell us that there are 2 kinds of causation, factual and legal. And then, because you know that both forms of causation must be present in a given case before there can be liability, you tell us that, because we didn't tell you, we didn't ask you, is there going to be factual or legal? We just asked it in a general manner. So then you will tell us, okay, both of these must be present. And then you go to the specific and you tell us well, the test for factual causation is the conditio sine qua non, and then you give us more detail, and then you apply it to the facts. And then if you find there is no factual causation, then it's not necessary to continue to legal causation, because then there can't be causation. But if you find there is factual causation, then you must tell us, well, now we need to go and look at legal causation as well. And then you tell us what the way is to determine whether there is legal causation. You tell us about the flexible approach, you tell us about Mokgeti and all of that, and you make an application again. So that's what we mean by start with the general, go to the specific, go to an application. Same kind of thing with fault, for instance. You will tell us two forms of fault, intentional negligence, but that is only if we ask, was there fault in this scenario? If we ask, was the person negligent, then obviously you're not going to tell us, oh, okay, there are two types of fault, intention, negligence, because the question doesn't deal with intention. It asks specifically negligence. So then you can go directly to negligence. But again, then you start with what is general under negligence. So you tell us about the reasonable person test. But say now, if you read your facts, you see, oh, okay, the potential defendant in this case is 13 years old. Okay, this is a youngster, this is a child. So after you've given us some generalities about the law of about negligence specifically, then you will tell us, but the reasonable person is the test is the main test, but in this case, because we are dealing with a child wrongdoer, we must now ask the question, do we use the test the same for a child wrongdoer, or is it adapted? And then you go into all the detail about that. So that is how you always start with what is general, proceed to what is specific, and apply every time to your facts, and always substantiate with reference to case law where you know case law that is applicable.
Prof, the last one is from Wonderboy Mutembu. Wonderboy is asking that does the principle of the fact that the owner of a trading store has a duty to keep the floor of the store reasonably safe for the public using it applying in assignment 2? I hope I was clear, Prof, or should I repeat it?
Yeah, just
what
repeat.
Saying that does the principle that an owner of a trading store has a duty to keep the floor of the store reasonably safe for the public using it apply in assignment 2?
Yeah, yeah. That's not the way I would approach the question, because where does one get that principle from? You know, where do you get the principle that the owner of a store has a duty to keep the floor reasonably safe? That doesn't necessarily sound like a rule of the law of delict to me, because remember, when you are dealing with delictual liability, your the person who initiates everything is always the plaintiff. So we start with what the plaintiff does. The plaintiff falls and slips, and now wants to institute a claim against the shop. So we ask, can we assist? Can we come to the assistance of this particular plaintiff? So we ask, in that specific scenario, was there a legal duty on the shop owner to prevent the harm that was caused to this specific plaintiff? So that's more the angle that we will normally use. So there's not necessarily anything wrong with approaching it from a general sort of a principle like that, but rather start from the angle of the plaintiff, rather identify what kind of conduct is it. Was it a commissio or omissio? Because that will determine whether you look at rights or duties, and then proceed from there.
Thank you, Prof. Prof, before we close, can you explain to the student the format of the exam paper? And the other thing is, please mention things like referencing, because they think that they should do footnoting. The app stresses that, and also the format itself. Can you kindly do that for the students' benefit?
Okay. Like I said, the questions will look very similar to this question that we have just discussed. Fairly long type questions with, we usually give you a little story, we tell you a little story, and you need to look what the instruction is and identify all the important things there so that you can apply what you have learned with insight. Most of the questions from those first elements, like I said, the question paper counts 100 marks altogether. You get 3 hours to answer it. It's You do that in your home, online, on your own device, but it's not an open book exam. So in other words, you can't sit with your books next to you. Your books must be closed. You are writing from memory. You are applying your knowledge, but it's not an open book exam. You're not allowed um, to contact other people, to assist other people, or be assisted by other people while you are doing the exam. This is your own personal effort. So the questions are not optional. You must do all the questions, and they will add up to 100 marks. In addition to these longish problem type questions, there will also be a few more direct questions where, for instance, we will ask, list the requirements for this, that, or the other. For instance, list the requirements for the say the doctrine of sudden emergency, or list the requirements for the actio de pauperiae, or whatever. And then obviously that's not an in-depth discussion. Then you basically, you always carry out the instruction that you get. So if it says list, then you list. If it says write an opinion or discuss in depth, that's when you discuss in depth. Okay. Citing of authority, because you do not have your books open next to you, you don't need footnotes or anything like that. You just say, for instance, you're writing on negligence, then you will say, the classic case on the general test for negligence is Kruger versus Coetzee. If you know that it was an appellate division case, you can write that, and you can say the appellate division decided in this case that the test for negligence works as follows. You place the reasonable person in the position of the defendant, and you ask whether the reasonable person would have foreseen the harm and would have prevented it, and whether the defendant's conduct deviated from that of the reasonable person. So that's the way that you cite your authority. And as I say, we are not going to expect of you to mention both the parties precisely, because some of those names are very long, and very often there's some kind of a insurance company or something in the case, like it's, say, Jones versus Santam Insurance Company or whatever. If you, in those instances, tell us the Jones case, that's perfectly okay for 1 mark. Or Kruger versus Coetzee is fine if you know both of them. State versus Mokgeti, if you say the Mokgeti case, that's fine. We must just see that you know what the applicable case is.
Thank you, Prof. Can you also stress that the exam will be invigilated and the hours, which is 3 hours? Because I see most students are not aware. I'm not sure if they've already received the timetable.
Yes. Like I say, it's 3 hours. You must do it in a given time slot. So in other words, it's not a take-home exam where you get, like, say, 2 days or 3 days to do a kind of portfolio. It's like an ordinary exam where it starts at a given time and it ends at a given time, and in that time you must answer it. As far as we know at this stage, it's going to be invigilated with the normal Invigilator app that you have been using up to now. But we will give you further information on that. We are still getting some information on the authorities about that. We will give you detailed instructions on where to access the exam. We will probably provide you with a specific link. But obviously, if it's going to be invigilated, and all the indications at this stage are that it is going to be invigilated, it would be best if you can have two devices ready. One device for the preferably your phone for the app, and then another device, preferably a laptop or desktop computer, for answering the exam. It can be done on only one device, but if you have access to two devices, that would be preferable. Obviously, you must be you must have everything charged so that it can work long enough. If you encounter technical troubles along the way, we will give you some pointers on who you can contact. As you perhaps have experienced in previous exams, we cannot always solve the problems. Then it could help if you can make a screenshot of feedback that you are getting about the problem, and if you could email that to us. So
Prof?
my apologies, just getting
Yeah,
some
I
water.
understand. I understand.
Sorry, just got some water. Yes, if you provide us with a screenshot of the difficulties that you are encountering, often that enables us to help you more effectively. Or if there are queries later on, then that enables us to deal with that. So yes, is there anything else? That's all that I can think of at the moment.
Can the invigilator app be on if they're using two tools of operation? Can it be on both or only on one? The invigilator app.
Yes, as far as I understand, it's best to separate them so that the Invigilator app is on the one device and your exam on the other one. But if you don't have access to two devices, then everything can be on one single device.
Okay, I think it's yeah. I think we've come to the end of the session, Prof. And because most of the questions were with regard to the app, the hours, and things, administrative things, which I think the student will get in their exam paper or they are already in possession of. But what we will do, we would still provide the clarity on them via an announcement. And so this brings us to the end of it. I'm not sure if you've got any word for the student.
Yes, I think I just need to add that we are probably going to send out quite a lot of announcements in these last couple of days running up towards the exam. Please keep an eye on your announcements. There are still lots of technical troubles around submission of assignments and so on which we ourselves do not have much clarity. As we get clarity from our technical people and from our authorities, we will try to communicate that to you. So please keep an eye on your announcements. That is very important. Oh,
Oh,
and obviously, thanks for attending, and our best wishes for your exam. Uh, I hope that the module was interesting to you. We were plagued by a lot of technical troubles this semester because we migrated from one electronic platform to another one, and we as lecturers are not necessarily the most tech savvy persons on earth. We are experts in the law of delict, not in IT things. And the university has experienced a lot of troubles. We are very sorry about that. But we hope that the content of the law of delict was interesting to you. I certainly regard it as one of the most interesting parts of the law. So we hope that was interesting to you, and we hope that you are able to bring your studies to a fruitful end and that the examination will go well. Thank you very much.
Thank you, Prof. Student, as Professor Knobel has already alluded, we wish you nothing but boundless strength and courage with your preparation for the exam, as well as your success in the exam. Please go out there and bring back the fantastic outcomes. Best wishes. And we will definitely be communicating with you by announcement. Bye. That's it. That's the end of it. Thank you, Prof.
Thank you very much. I'm going to stop recording now. And as ever, if you have further queries, please send us emails. We are flooded by quite a lot of emails, so the response time may be fairly long at times. Sometimes we don't know the answers ourselves and we need to look for the answers elsewhere. But please keep the communication channels open, and please watch your announcements, because that's where we will do most of our communicating. Thank you very much.
Thank you, Prof. Bye, students.